Okay, next case on the docket is 5730 Lake Underhill LLC versus Smith Horner LLP.
If it please the court,
Let me ask you, would you like to try to save some time for rebuttal?
yes, I would.
Much.
5 minutes.
Okay, so the yellow light will come on when you are into your rebuttal time, and you can save it for rebuttal or not. It'll be sort of up to you once, but
Thank
that'll
you.
notify you. Thanks. Go ahead.
My name is David Landis. I'm with the firm of Mateer and Harbor in Orlando. With me today is my partner, Brian Wagner, and my clients, Dr. and Mrs. Sun.
If you could speak up just a little bit.
Is that better?
A little bit better. If you could speak up just a little bit.
All right, thank you. This case is about a dispute involving an easement granted as part and parcel of a lease. The appellee has argued and the trial court has found that the easement granted as part of a lease with a specific term.
Is it your position that there was an easement, but it was an easement for the period of the lease term?
Yes,
All right. And so that raises the issue, when did the lease expire, right? There's an argument that the lease was amended to add some additional terms. And
that's correct.
than the original term of the lease. So I think your position in your brief was that, well, the owner of the shopping center didn't sign the amendment to the lease.
That's correct.
The trial court found that wasn't necessary because the landlord at the time the original lease was executed and the owners of the shopping center, and including Mr. Stark, signed off on the lease saying that the easement would be in effect, and if you're correct, for the term of the lease. So if that's the case, and Mr. Stark signed the paragraph saying that he agreed with paragraph 10, implementing the easement, why would the subsequent owner of the shopping center have to sign the lease as well when the original lease agreement was between the landlord and the tenant?
Because the joinder was to paragraph 10 of the lease. It didn't talk about any extension of the lease whatsoever. And what has happened is by doing that amendment...
Excuse me, but isn't there a provision in the lease that says that it can be amended and that they amended the lease to add some additional terms?
It did say that, but what...
And that was properly done, wasn't it? Wasn't the amendment properly done? You're just saying that the subsequent owner of the shopping center didn't acquiesce or sign the lease.
That's correct.
For the extension of the easement, right?
That's correct.
All right. And the trial court found that was not necessary. Why isn't that correct?
Well, because it increases the burden on the servient estate, which is contrary to Florida law. What has happened here, these two parties have gotten together, which are, by the way, related parties now, and they have signed these amendments, or one of them.
Yeah, but here's what's bothering me about that argument. The lease properly said that in paragraph 10 that there would be an easement, and your position is easement during the term of the lease.
Yes.
Mr. Stark signed a subsequent document saying he agreed with paragraph 10.
Well, no, actually that was done at the same time as the
If there
lease.
was going to be an amendment of the lease, it would be between the landlord and the tenant. And if they properly amended the lease to extend it for a period of time, why wouldn't that extend the term of the lease?
Because it increases the burden on the servient estate without the joinder of the owner of the servient estate. That was not contemplated at the time the lease was executed.
I understand your answer, but let me ask you this. Didn't the original 30-year lease include an option to purchase?
It was a 15-year lease that, with 3 5-year extensions.
Right.
And there was an option to purchase.
Okay, and didn't the tenant ultimately exercise the option to purchase?
Well, I don't think it was actually done that way, but that was subject of other litigation. But ultimately, an entity related to the tenant purchased that.
So I was tracking with your argument until I read the option to purchase. And this is a different thing that concerns me, and that is if the owner of the subservient estate agreed to this easement for purposes of a lease that includes an option to purchase, why wouldn't that necessarily include any future purchase of the property? And otherwise, it's not expanding the easement originally given if the original lease to me includes an option to purchase. I would agree with your argument if there was no option to purchase, but if the original owner of the subservient estate agrees to the purchase of the property with that easement, why is that an expansion of the estate?
I don't see that as being a different issue. The issue still comes down to whether the servient estate is to be burdened by this perhaps forever.
Right, but I mean, if I'm signing, is the owner of the servient estate, if I'm signing a document saying, I agree to this easement pursuant to this lease, which includes an option to purchase, then isn't that an agreement that this lease is going to last? I mean, it really wouldn't make any sense to say, go develop this small parcel of property knowing that there's this easement and you have an option to purchase, but if you purchase, the easement goes away. I mean, that doesn't seem to make much sense.
Well, I'm curious as to why that would make any difference whether the option were exercised or not. It seems to me that the servient estate is being burdened for way more than was ever contemplated when the joinder was executed.
How is the servient estate being burdened more when the lease requires that there be an easement, and then the lease has a term, and then the lease says it can be amended, and the amendment extended the term of the lease, and all it did was, when it extended the term of the lease, it extended the term of the easement pursuant to the lease requirements, which Mr. Stark agreed with. So
Mr. Stark agreed that
he agreed with paragraph 10.
That's correct.
Right, and it
says solely for purposes of paragraph 10. The joinder is very clear. Arthur Sark, being the fee simple owner of the above described land for valuable consideration and to induce lessee to enter into the lease, hereby joins in this lease.
Mr. Stark testified that he thought it was his understanding that the easement would terminate with the lease, but he never testified that he thought the lease would end after the 30-year period and couldn't be amended to extend the lease even further. He never testified to that, did he?
I don't believe he did, but I know he never testified that it was his intent that it be permanent.
Well,
he never said that.
No, I'm not talking about permanent. I'm talking about when did the lease expire. Your argument is that the easement expires with the lease.
Yes.
Right. When did the lease terminate? And their argument is that the lease is still in effect because there was an amendment that was made to the lease that gave them 3 additional option periods, right?
There was, but
My question to you is, why didn't that extend the term of the lease? The lease is still in effect.
It may have extended the term of the lease, but it didn't extend the easement because Mr. Sark, Arthur Sark, says he is, by his signature below, solely to indicate his agreement to the provisions of paragraph 10 of the foregoing lease.
Right.
That's it.
But paragraph 10 gave the easement for the purpose of benefiting the property that was leased to the tenant. There was nothing to prevent the lease from being amended to extend the term of the lease. That's my concern here.
Well, but
and I don't see why your argument that, well, the subsequent purchaser of the shopping center had to sign off on the lease extension when she wasn't really a party to the lease. That had already been done by Mr. Stark.
Well, because her property is being burdened by this, perhaps forever. The easement paragraph is actually unenforceable standing alone. There's many problems with it. The only way this works is because of the joinder. I mean, Mrs. Sark was granting to the tenant an easement on property she didn't own.
Right, but that's cured by the joinder, so why is that an issue?
Well, because the only operative portion of any document here
Says I agree.
is the joinder.
Right, so.
The joinder.
Right.
And he just joined to paragraph 10.
I mean, that's the only paragraph he had to join. Why would he want to commit himself to other obligations
But
with the lease?
but the argument I'm hearing is that he is bound by the terms of the entire lease, which provides for an amendment, and he didn't sign off on that.
Well, can I get?
Okay, I'm sorry, just one more
Go
question.
ahead, go ahead.
You know, this is what's bothering me about your argument. When he signed off agreeing with paragraph 10, there was nothing to indicate, and the lease was between the landlord and the tenant, and the lease gave those two parties an opportunity and the right to extend the lease if they wanted to. We're not talking about a permanent easement here. We're talking about the issue as to when the lease expires. Your argument is that the easement extends during the term of the lease. And that's what Mr. Stark basically testified to as well. He said, I thought and intended that the easement would last as long as the lease lasted. And then they had this amendment that extended it for 3 separate periods.
And that was part of the initial lease.
Pardon?
That was part of the initial lease.
And that's right. And if Mr. Stark agreed with paragraph 10, and paragraph 10 was binding on the landlord and the tenants, then it should be binding on the subsequent owner of the property. That the easement ran over. That's my point.
Well, I don't know how you bind the servient estate.
If the landlord and tenant can amend the lease to extend the easement under paragraph 10, and Mr. Stark signed off agreeing with paragraph 10, then the landlord and the tenant should be allowed to amend the lease to extend the term of the lease, thereby extending the term of the prescriptive easement.
Well, it's not a prescriptive easement, it's an express easement.
Okay, you disagree with that, so. And your position is that the owner of the subsequent owner of the shopping center had to sign off on the lease as well?
Yes, because the extensions of the lease are creating a further burden. This could go on ad infinitum. This could become a de facto permanent easement.
What about the issue, the trial court found that the specific language creating the easement was ambiguous?
We disagreed with that at trial. We think that...
Agree with it at summary judgment time, did you? At summary judgment, didn't you argue that it was ambiguous?
We didn't argue the summary judgment.
Your client's attorney.
Yes.
Okay. They successfully argued that it was ambiguous to avoid summary judgment, but now they want to argue that it was not ambiguous?
Well, the trial court found it was, and we went ahead and put Mr. Sark on and got his testimony. So, you know, I think that that's, at this point, moot.
Well, what was your purpose in arguing that it was ambiguous to begin with?
That it was ambiguous?
You originally made that argument in the trial court below.
Yeah, and
Why did you do that?
I would suspect it was to avoid a summary judgment. That's all I don't know.
Now, the trial judge found that this was a permanent easement, correct? Am I misreading that? Didn't the trial judge find that this was a permanent easement?
Yes.
Okay.
But the trial court also found that there was a prescriptive easement and an implied easement, both of which are inconsistent with an express easement.
I agree with you on the prescriptive easement part. I don't think those elements were met, but we're talking about whether the language of the lease was ambiguous. And then if it was, then the trial court had the requirement and the right to hear testimony from people to clarify the ambiguity, and that's exactly what the trial court did. And he found it specifically in the judgment that the credibility issue bode more for the people that testified that we intended, or the lease was intended to establish a permanent easement. He found that was the most credible testimony. So if that testimony was properly introduced and the credibility issue bodes against your client, the issue goes back to whether the lease was ambiguous in the first instance. If it wasn't ambiguous, then all that testimony doesn't really matter. If the lease is clear on its face and the terms, they never needed that testimony to begin with, right?
That's true.
The issue then becomes, is the lease ambiguous?
And I am here today to say I don't think it's ambiguous, but he admitted that testimony.
Argued in the trial court below that it was ambiguous, and now for purposes of appeal, you want to say that it's clear and there's no...
Well, if you read the plain terms, it says it's given as part of the lease. And the joinder is to paragraph 10 of the lease. Sir?
And the trial judge found the lease was still in effect until at least 2020, correct?
Yes. Yes.
Okay, I know that you're into your time, but back to, and maybe it doesn't make sense, and that's the problem, but you agree, because that was your response to my question, I don't understand it basically, but we agree that Arthur Sark granted an easement over property he owned in favor of or to benefit the tenant's land, correct?
The tenant.
Right.
Just the tenant.
We agree that Arthur Sark, so the question is, what did the parties contemplate in terms of the duration of that easement? That's the question that you now say is unambiguous, but it was argued that it was ambiguous. What did Arthur Sark contemplate, correct?
Okay, yes.
Okay. Now, and here's the troubling fact for me, is that lease in which he gave that included an option to purchase, for the tenant to purchase that land. So why, in light of that fact, it seems like he would have contemplated that this could become permanent if that option is exercised. Why would that not be something that he would contemplate if he's giving an easement in favor of the tenant's land and that document that he's agreeing to has an option to purchase?
Because he only agreed to paragraph 10. That's exactly what the joinder says.
So you're saying he never agreed to the option that was just something
Right.
he never even contemplated?
No, he agreed to paragraph 10. Because without his joinder, there is no easement.
Exactly. Isn't the lease, though, the word lease here a little ambiguous itself? Because this one paper transaction was a lease. It included an option to purchase and an easement. So even what is meant by the lease is a little bit up in the air, where it was until the trial judge decided?
No, I think it says he agrees to give the easement to induce the lessee to enter into this lease and joins in the lease to indicate his agreement to the provisions of paragraph 10 of the foregoing lease.
It says, and assigns for the benefit of the property leased herein. The property leased herein is subject to the terms and conditions of the lease. The lease specifically required they could amend it. They amended the lease to add 3 additional terms, and Mr. Stark agreed to that when he executed the paragraph saying, I agree to paragraph 10.
Well, I disagree. I think he agreed to paragraph 10, which was simply the easement portion of it. I think his testimony, as I recall, is that he didn't even read the whole lease, or didn't remember whether he had read it.
Okay. You have it.
I've got a minute left, so I'm going to stand down.
Thank you very much.
May it please the Court. Tony Kowalczyk with Moy O'Brien, Pickard, and Dillon on behalf of the appellee Smith Horner LLP. The trial court's final judgment should be affirmed. The trial court correctly determined, based on the testimony at trial and the language of the easement itself, that the easement granted by Arthur Sark for the benefit of his mother's property that was leased and then later sold to Smith Horner, it burdened the shopping center property, it ran with the land, was permanent, and is binding on Arthur Sark's successors in interest, which include appellant 5730 Lake Underhill LLC, who's the current fee simple owner of the shopping center parcel. I think it's important to keep in mind that there were many findings of fact in the final judgment that were based on admissions by the appellants in the joint pretrial statement of facts and also during a document called admissions of fact that were filed during the trial. And that these were really key underpinnings to the court's final judgment. The appellants agreed, and this was listed as findings of fact in the final judgment, that paragraph 10 of the lease, in fact, was an easement that Mr. Sark joined the lease. He signed a joinder as operating as his agreement to the easement, that the purpose of the easement was to allow the free flow of traffic between the Popeyes parcel and the shopping center parcel, and that the easement was for the benefit of the Popeyes parcel, not just for the benefit of the tenant, but it was actually for the benefit of the property. The easement did not contain any expiration date. It was not limited to a specific period of time. The appellants intentionally blocked the easement. There's no contest, there's no dispute about that. And that our client had the standing to enforce the easement that was granted for the benefit of the Popeyes
Their argument
parcel.
is that when the amendment was executed between the landlord and the tenant, that at the time, the current owner of the shopping center never agreed to extend the term or extend the length of the easement that was created by the lease. And of course, I can see the argument your way, that was because Mr. Stark agreed to paragraph 10 and it was for the benefit of the property and the lease allowed for amendment and that sort of thing and the extension of the term. I can understand that, but don't they have a legitimate argument when they say that because the owner of the shopping center, the subsequent owner of the shopping center, didn't agree to extend the term of the easement, that burdened their property?
No, Mr. Sark and his successors, they were not parties to the lease. There was no requirement that they sign an amendment to the lease. The lease provided that it could be amended. It was in fact then amended by the landlord and the tenant, but there was no requirement that the owner of the shopping center parcel.
I understand the owner is not a party to the lease regarding the Popeye parcel, but the owner does have an interest because extension of the lease essentially extends the length of the easement over their property to the shopping center.
Right, but Mr. Stark, when he joined when he agreed to the easement and signed the joinder to the lease, can't be read in a vacuum. The paragraph 22 of the lease would provide.
When Mr. Stark testified, did he testify that he thought that the easement extended during the period of the lease, and did he say that the lease was to terminate in 30 years, or did he say that just extended during the term of the lease?
I don't think Mr. Stark, I don't recall exactly what his testimony, but I do not believe that he testified that it was 30 years and that was all. In fact, I believe Mr. Stark's testimony was when he was asked, he couldn't even recall if he had even read the lease at the time he signed the joinder, and the trial court found that his testimony just wasn't credible.
When they argued to the trial court below that they thought that the lease was ambiguous, opposing counsel thought, well, he thought they did that to avoid summary judgment. Why do you think they made that argument below?
Well, I agree. We had argued to the trial court that we thought the language of the easement was not ambiguous as well. We thought it was clear and unambiguous that it granted an easement for the benefit of the Popeyes parcel that would run with the land and was permanent. The trial court disagreed. The trial court said, no, we found there's ambiguity. The words "as part of the lease" created an ambiguity as to whether it was tied to the length of the lease.
Who drafted this lease?
Mr. Smith drafted the lease with input also from Mrs. Sark's attorney and a dual agent that was working on behalf of the original tenant and Mrs. Sark. But the trial court correctly determined that the easement was ambiguous. And
So it was your client that essentially drafted the lease, Mr. Smith? I mean, he was, isn't that right? I mean, it was your client or their predecessors and interests that drafted the lease?
correct, with input from Mrs. Sark and her attorney as well.
Did they ever present the argument below, the opposing counsel, that it was ambiguous and therefore should be drafted strictly against the, it should be interpreted strictly against the drafter of the lease? Is that why they made that argument?
They did. They made that argument, I believe, at trial for the first time. And it's a secondary source of contract interpretation. If there is a
Don't you think if they were going to, if the intent of the parties was to establish a permanent easement, that they would have done it, not in a lease, but in a separate document saying that concerning easements and having that recorded for the specific purpose of establishing a permanent easement rather than doing it in a lease agreement?
I mean, that is an option, but there's no requirement that it be in a separate document. And that's why Mr. Smith testified at trial when he was using those words as part of the lease, that he was saying...
No, I mean, obviously, that's self-serving testimony because it's to their interest to say that this is a permanent lease because they subsequently bought the property. But it seems to me that if they were going to establish a permanent easement, that the proper way to do it would be to do it by document for that purpose rather than trying to insert it in a lease and then the lease expires and then saying, well, the lease established a permanent easement permanently forever, even after the lease expires.
It's an alternative way of doing it, but it's not required. An easement can be in a deed, it can be in a lease, it can be in all sorts of documents. When the parties were initially negotiating for the lease, that it was our client's first understanding that there was an express easement had already been granted.
I'm not so sure that the language of the lease agreement is ambiguous because it says right for the right of use and into the parking lot, the area described in subparagraph B, and basically it says that the easement is being granted of the lease premises and being described in Exhibit B attached to and made a part of the landlord is part of this lease hereby grants to the tenant and the tenant's guests, invitees, so on and so forth, for the benefit of the property leased. So as long as the property is leased, it seems to me that there would be an easement. But if the property is not leased anymore, then there wouldn't be an easement. How is that ambiguous?
Well,
It says property leased herein.
right.
So if the property is not leased anymore, then there wouldn't be an easement, right?
Well, I think it's describing the property at issue. If this was a
It's for the
deed,
for the benefit of the property leased.
right. And the property leased herein was the Popeyes parcel, and it says it's for the benefit of that property. And the appellants have admitted that the easement was for the benefit of the parcel. It wasn't just for the benefit of the tenant, it was for the benefit of the Popeyes parcel. And I think, Judge Kest, had...
When did they admit that?
This was admitted in their pretrial statement of admitted facts. It was fact number 13.
All right.
Let me ask you about the damages claim. You didn't put on any specific claim of damages or proof of damages at trial, correct?
Correct.
So you're limited to nominal damages?
We are, Your
You
Honor.
agree that under Florida case law, $2,500 is more than a nominal amount?
Yes, under Florida case law, there are cases out there that state that amounts even less than $2,500 are more than nominal damages. However,
At minimum, you would agree we'd need to reverse the damage amount.
well, there's nothing in the case law either that says that it must be $1, and here, our clients had to litigate for over 3 years, which is not an inconsequential or insubstantial amount of
The damage
fees.
amount is the loss of revenue to the Popeyes parcel because the parking lot was temporarily blocked. It's not your litigation cost, correct?
Correct.
Okay.
So, but what we're saying, I mean, based on, I mean, I know it's not a Florida case, but there are cases from other circuits where nominal damages have exceeded $1, and our position would be based on the kind of the stubborn litigiousness of this
What's the highest
case.
amount that they say is nominal damages?
I'm sorry, what was it?
The highest amount that the case law says is the proper
Well, it was
amount.
$1,000.
How much?
1,000.
Well, 1,000 has been reversed as being too high for nominal damage.
Okay, you know, I'm talking about the case that we had cited too in our case. It's not a Florida case.
Right, right.
But in Florida, what's the lowest amount that's not been reversed, I guess? To put it,
I don't recall, Your Honor.
would it be substantially less than 2,500?
Yes, yes,
So you
we-
want us to conflict with the other DCAs on that issue?
No.
Okay.
And that's not, I mean, that's not the big burning issue for you anyway. Is it 20 Who cares? You don't really care if the $2,500 goes away as long as you get your easement right.
Correct.
All right.
So like I said, based on the trial testimony of Mr. Smith and Mr. Horner, and based on the language in the easement, we would ask the court to affirm the trial court's final judgment below, unless there are other questions.
What about the prescriptive easement? Tell me how you prove that.
The prescriptive easement was in the alternative,
I know,
first
but
of all. but-
The trial court found there was prescriptive easement too, and I have problems with that.
Right. The only element that the appellants take issue with, as far as the elements of a prescriptive easement being met, was that...
Not adverse.
Right.
And
That
you
it was
agree it was
without the
not
permission and it was not adverse. The trial court found
I
that...
agree that if it's non-adverse use, that you can't establish a prescriptive easement.
Correct.
So you agree that that finding was incorrect?
Well, no, I don't find it was incorrect. I'm
No
saying
prescriptive easement.
excuse me?
You agree that there was no prescriptive easement?
No. I'm saying that I agree that if the use of the land was with permission, there would be no prescriptive easement. However, the trial court found that the appellants had taken conflicting...
But they agree that it was, I mean, everybody agrees it was with permission for an extended period of the time.
Well,
So to the lease.
not, in the trial court, Mr. Sun testified that he didn't believe that paragraph 10 was an easement, and he had testified that he had blocked the easement with his car to block access. He had, the Suns had blocked the easement several years later with bumper blocks in between the easement, and that Mrs. Sun, through her attorney, wrote a letter to Smith Horner saying that the Popeyes patrons were trespassing upon her land. Mr. Stark then testified that
That was
he
all
didn't
after
think...
that was all after the term of the original lease, correct?
No, this was before.
During the term of the original lease?
Yes. The parking of the, Mr. Sun's parking of the car between the parcels was before the first 30 years. The bumper blocks were before the first 30 years, and the letter was also before the first 30 years. So the trial court found that those facts suggested or supported a finding that there was not permission granted for the Popeyes patrons to travel over into the shopping center parcel.
Any other questions? Thank you very much.
All right, thank you.
In a case that this court just decided earlier in the year called Burlington and Rockenbach involving contract interpretation, one of the statements that the court found is that a contract should not be interpreted to achieve an absurd result. And to find that this is a permanent easement given as part of a
You
lease.
interpreted the contract that way in the trial court. You said it was ambiguous. You said the contract was ambiguous. But you're just saying that because it would have result in an absurd result. That
If,
it
for
could be
instance-
interpreted the other way.
Well, but if, for instance, the lease had been breached,
So now you're saying that, I guess you're arguing that maybe the contract is ambiguous, but we should interpret it so that it doesn't achieve an absurd result, right?
well, I think it would achieve an absurd result to find this as permanent if the lease had been breached a month into it, or 6 months into it, or 6 years, and the tenant is no longer there.
In the trial court, did you argue that the lease was ambiguous so that you could make the argument that it should be interpreted strictly against the drafter of the lease?
We did make that argument at trial,
Pardon?
at trial.
All right.
Okay, let me see. Any other questions?
No.
Okay, thank you very much.
Thank you.
for your argument. As announced at the beginning of this session, we will take a